Yes.
My lord, my lord, may I pray leave, my lord, to move one urgent, my lord, public interest litigation, my lord, regarding,
File it. No urgency.
my lord,
With your lordship's leave, may I mention
Inclusion,
my
inclusion, upgradation, etc. next week. Any leave to file without certificate copy granted. Yes, sir. First,
My lord,
we'll pronounce the judgment, Patak. First, we'll pronounce the judgment.
my lord, I'm sorry, my lord.
Mention one matter, my lord, to appear as to be mentioned because your lordship was pleased to deliver a judgment on 31st July. There's a typographical error, my lord.
Yes, to be mentioned.
My lord, I'm
Told
sorry.
you.
My lord, if your lordships kindly permit me, my lord, to seek your lordship's leave in this matter, my lord, to move it unlisted. My lord, the issue is very sensitive, my lord. It relates to the vandalism that have been carried out yesterday
Wait,
in the
sir.
wee
You wait,
hour.
sir. There is a supplementary list. You wait. Yes, please call for.
Item number 1. Sir, I'm here. Thank you. My name is Dr. Kunal Sahu, my lord. I have come here in an excruciating urgent situation because poor patients are dying today.
Please wait. The matter will be called. Then you
Well,
can.
my matter is not here. I'm here.
You are here. You are here, doctor. We will hear you. There's a supplementary list. 6 matters are
I
listed.
have not filed it. I have
You have not filed it.
no.
You please
my lord,
be here.
It's because I be here today. I'm going to file it today. But the doctor's right. Now this death happened.
Once again say we will hear you when the matter is called. We have got 2 judgments to deliver. Please wait. Please call.
নমস্কার স্যার, আমি একটা কথা বলতে চাই। আমি পিটিশনার ইন পার্সন 28,142/2013 একটা মামলা ছিল।
I don't understand.
স্যার বাংলা একটু বলবার ব্যবস্থা
I
করুন।
don't understand. Don't mention elsewhere. Please call, sir.
Item number 1. Lordship, I am for the appeal. Lordship, I am for the appeal.
But I beg to appear for the petitioner. I am the petitioner in person. Item number 3.
This is a judgment being delivered. Please
Yes.
wait.
Yes.
For all the reasons as aforesaid, this court holds that the learned single judge was right in rejecting the prayer of the appellant for restoration of possession. Accordingly, the appeal and the connected application stands dismissed. There shall be, however, no order as to costs. The appellants are left free to approach the proper forum for appropriate reliefs in accordance with law.
Great.
Judgment. For judgment is the original site. Item number 1. Item number 1, original site for judgment.
In the result, it is held that the seizure by the preventive department of the customs is valid and the seizure is not vitiated for the reasons contended by the writ petitioner, and consequently the order passed in the writ petition is set aside and the appeal is allowed. The customs department are directed to proceed with the investigation and take the matter to the logical end in accordance with the law.
Matters from the supplementary list. Item number 1 to 6.
Lord, with your lordship's kind leave, my lord,
I am the petitioner in person.
appearing virtually, my lord, on behalf of the petitioner in the second writ application, my lord.
But I am for the I am the petitioner in person. Item number 3.
Mr. Banerjee, the reason we listed this was from yesterday morning, several emails have been addressed to me reporting about the vandalism which has taken place in the hospital premises.
Yes.
And there was also a prayer saying that we need to file an application, etc. Therefore, we thought it fit to list the matter under the supplementary list under the caption to be mentioned. Now, what has happened?
As far as the vandalism is concerned, my lord, I, without knowing why the matter was listed, I just took some arbit instructions from the authorities, my lord. Without, as far as what steps we have taken, my lord, from the vandalism, my lord, there was a suddenly a mob of about 7,000 people.
7,000.
7,000 people gathered over there. It was a demonstration was sought permission, but till for up to that period, whatever 200, 300, 400 people were there. But on that day, it swelled up to that big a number. And they carried out a huge, if your lordship so desires, I have videos with me, how they sort of broke open the barricades, moved the barricades, police trying to resist them, everything. Tear gas shells were fired to bring them into under control. 15 police personnel were injured. The deputy commissioner of police was seriously injured. Police vehicles were also damaged. Not only that, my lord, the emergency was ransacked. But however, one good thing is the place of occurrence upstairs, which is on the floor, that is untouched, totally protected.
But one thing, normally even if 100 people gather, there is always an intelligence wing with the police. Intelligence wing with the police. In fact, we came across the same issue during Hanuman Jayanti. Because people, threw bricks from the 3rd floor. So therefore, the court commented on saying that unless it was a pre-plan, the bricks could not have been lifted to the 3rd floor, and there should have been movement of vehicles. And there was a serious failure on the intelligence of the state police. If 7,000 people are together, it is very hard to believe that the state police intelligence did not know about
There was supposed to be a demonstration outside, but
why did you grant permission?
Outside, no permission is taken. They just give intimations. No one takes permission.
For all and sundry reasons, you pass a 144 order. When there is so much of commotion is going on, the doctors are on strike, there are demonstrations, you should have cordoned off the entire area.
This was the demonstration which has been conducted, but your lordship knows that evening, or rather that morning, there was a movement, that there was a movement at the night. So, at every place over Calcutta.
No, if suppose 7,000 people have to come, they can't come walking. They should have been brought by buses or trucks.
There were streams of people
Exactly.
Various places. There are various processions marching in. But that was supposed to be peaceful.
Failure of state machinery.
Absolutely.
What happened, that day, they were ready for 500 to 700 people, which was
that sort of force was present over there.
Every day there was 12.
And the force couldn't protect their own men. You say that the policemen were injured.
Policemen were also injured. That is why.
Sorry, state of affairs. And how do you think these doctors will be in a position to work fearlessly?
Well, now it is completely under control, and there
we have now deployed all the commando forces and everything is deployed over there, my lord. Now, my lord, number of arrests have been made, my lord. What we have done is now we are taking the entire video footage. A lot of video footage of the incident is available. On the basis of that, we are trying identification of. We have arrested a large number of people. The process is still on. But
these are all things which you are going to do after the incident.
Lordship.
Should not this incident be prevented? What measures were taken? That is what is bothering us. So many emails have been received reporting about various. We don't want to. If we can ask those petitioners to file an affidavit. Some of them are petitioners.
I have my affidavit ready. May I interfere, my lord, for a second? I think they will kindly bear with me. At 3 o'clock, this honorable court directed handing over the investigation to the CBI. Around 6 o'clock, that information received, I had to rush to the RG also, that they are demolishing the place of occurrence. That was the complaint. That I had rushed. I had also called up an advocate for the CBI that since the investigation is now under your control, it's your duty. Now, when I reached the spot, yes. Now, when I reached the spot, I found the doctors, agitators, students, they had become so much aggrieved, agitating. Then the demolition work was stopped but a portion of it was demolished, admittedly, after the order of the Honorable High Court.
No,
And
this
then-
is not a correct submission, my lord.
Several attempts have been made, my lord. Mr. Banerjee, let me narrate the incidents. If I am wrong, you correct me. I have no quarrel with that. Then, my lord, at the date of night, when there was, my lord, a demonstration, some sort of spontaneous demonstration pan-India, the women who were gathering, they say the night is ours. At the 4 o'clock or 5 o'clock, the Honorable Chief Minister delivered a fiery speech, not only, my lord, targeting the lawyers, I forget about that, and said, you have demonstrated for 3-4 days, now I will start a demonstration. And at the date of night, hooligans, 40-50 hooligans, maybe 70-80,
Not 7,000.
not 7,000. But they suddenly, my lord, attacked. The first attack, my lord, the place of demonstration by the doctors and students and youths. They demolished the entire Samiana, their stage, everything demolished. Then they entered into the hospital. Police were there, police outpost was there, police outpost was vandalized. I feel sorry to say the Calcutta police was so helpless. They got themselves hide behind the demonstrators so that the attack on the demonstrators be there, demonstrators would save themselves. And they vandalized the emergency ward. They went up to the 3rd floor was the instruction. 3rd floor means not the 4th story, according to us. 4th story is the place of occurrence. Unfortunately, they misread, and 3rd floor they arrived and demonstrate and demolished a part of it. Thereafter, it appears the police commissioner arrived there. When he was there on spot, still this hangama went on uninterrupted. And the police commissioner says, it's on record, that we had information that this might happen. But what can I do? There are demonstrations throughout the city, and I suffer from lack of logistical support. Look, this is on record video statement of the Commissioner of Police. But what is happening? Government hospital emergency ward is demolished to the ground. Police outpost demolished to the ground. ENT. But was it not pre-planned? Was it not the, my lord, if I may use that expression, my lord, the instigation by highest authority? Give them the bad name and kill them.
No, the second portion of your submission, we can't.
I'm just placing, the lordship may not.
On the first, probably, prima facie, it appears to be pre-planned.
Yes.
Otherwise, from what Mr. Banerjee says, on behalf of the state, that 7,000 people, if they have gathered, obviously it is 100% fake. Assuming that
this is
15 people have gathered, probably from different angle, they would have entered the hospital premises. That is understandable.
But with humility, 7,000 is not the mystery. We never said that. We are saying, Malad, that mob, Malad, the demonstration swelled to 7,000. Out of which, Malad, as Mr. Banerjee...
What are they demonstrating for? In fact, the rapid action force should have prevented them from at least 1 kilometer before.
Was at that site where the rally was being taken care of. DYFI was putting up that
They have the responsibility, my lord, to differentiate between the mob as well as, my lord, the persons, doctors who are agitating, my lord.
But with your lordship's kind leave,
I will only make a
permitted-
prayer, my lord, let the CBI, my lord, also take up the investigation so far the vandalism is concerned.
Yes.
Because this is a part of...
But furthermore, my lord, I have made a prayer before your lordship, my lord, for deployment of central paramilitary forces. Because the situation is as such, it goes on record that the commissioner says that even after there was information, he was helpless. So considering the failure of the state machinery, my lord, the important essence of it is that, my lord, CBI has taken up the investigation. There is the crime scene in the Arjikar hospital. The police has failed to protect that. In view of such circumstances, my lord, I am humbly beseeching your lordship, my lord. I have also addressed a letter to your lordship via email, my lord, with such fact, my lord. And considering, my lord, the fact that Mr. Bhattacharya was addressing, I had also preferred a CAN application with regard to the crime scene that was being renovated in the name of innovation, evidences were being wiped out. On the self-same day, I have made a complaint to the CBI authorities, and thereafter, my lord, I sought leave before your
May I
lordship
submit now?
to file a CAN application.
May I submit?
My
My
lord,
a lot of submissions are
My
being
lord,
made.
with your
I
lordship's
thought I
kind
will
leave,
not
my lord,
interrupt
if
anybody,
I
but
may
not
just add
things
to
are
it, my lord, once, if I may just add to it once, my lord, there were letters which have been addressed to the Secretary, Ministry of Home Affairs, Union of India,
yes,
and my lord, the director of CBI,
CBI.
by my lord, the leader of the opposition, in item number 2, my lord. The prayers are, my lord, that this is a continuation. So,
No,
my lord,
But
CBI
similarly, in item number 2.
I have a very small, a very small. In the last occasion, Lordship have observed that there is no complaint has been lodged by the principal and the authority. Millard, on that score, I could not apprise your Lordship. Millard,
You file an affidavit.
I am not in a position.
You file an affidavit.
No, I have.
You file an affidavit, sir.
Lodged. I have informed the police and
You file an affidavit. Sir, you file an affidavit. Sir.
I did your Lordship the difficult. Millard, your Lordship has made aspersion against Mr. Sandeep. Now there is incident happened on the Millard other. Millard, except few people gathered in his house and wanted to set the fire. Millard, for
Why you seek police protection, sir?
No, we have already deployed.
even
Because we have made all our prima facie observations. We have also made a prima facie observation that your client is a very powerful person. So therefore, don't worry. Police will give you adequate.
that question doesn't come. Millard,
Yes, it does come. It does come.
Yes.
kindly give a
You challenge our order, sir. You challenge our order. You challenge our order. As we have signed, the order has been uploaded. It has to be implemented. Otherwise, we'll take suo motu contempt. If you want to bring on record anything, please file an affidavit. Let us test the correctness of your submission based on affidavit. Let him come and affirm an affidavit here. We will take it up.
Now may I?
In the meantime, the state is with you. There's no problem. They will post 500 policemen in your house. Nobody can set it on. If you don't trust the state police, please inform the court. We will request the central forces to guard your house.
I am all along with cooperating with the investigation agency.
We will see, sir. We will see. Nothing will happen. Nothing will happen. Let him be peaceful at home. Let him relax for some time.
Well, I believe Mr. Bhattacharya is appearing, Millard.
No. You are appearing for the doctor. Yes, you file an affidavit.
For the doctor or his family, Millard, we have already taken steps for the court, Millard. The Honorable Single Judge, Millard, we have taken leave to move a matter, Millard, on an urgent basis because, Millard, his entire house was, Millard, he was out, Millard, by a huge mob on the 15th, not intervening night, 14th and 15th.
But you don't require a court order, sir.
No, we require.
No, they will take care.
Unfortunately, they have not.
They will
Unfortunately, they have not.
Definitely.
With deepest of respect, Millard, they have not. Now, therefore,
You move the single bench letters.
Yes, may I now submit? Well, I've been trying to submit for some time. First and foremost, may I say that as of now, and I say now, the PO is secure. All these allegations that the PO has been demolished, destroyed, nothing is
Okay.
correct.
Then you file an affidavit.
I can, one more thing, may I just say? As far as the demolition work that happened, that was not anywhere, that was not in the PO or anywhere. That is for other room because there was a long-standing demand.
Sir, what was the urgency, sir?
The urgency is not, I'll tell you, Lord Tribunal, that it's a restroom for doctors. That has got nothing to do with the PO. This entire work that is carried on, I say.
All right, you go to any district court complex. Yes. You find out whether the ladies have got restroom. You go to Siliguri. You go to Siliguri, sir.
But
I am not talking off my cuff.
No, I am saying.
I say this with responsibility.
Yes.
And you are saying you go and visit the restrooms here. What has the PWD done?
Today, when as far as the PO is concerned, the PO is fully secured.
Yes,
when the demolition work carried out was outside, much further away from the
PO. How many patients are there? We'll close down the hospital. We'll shift all the patients to some other government hospital. We'll convince the patient party to cooperate. We'll shift everybody, close the hospital. Close the hospital. How many patients are there? Close the hospital, that will be the best. And
That-
this story is saying that within 12 hours restroom has to be provided. See the conditions, sir. See the condition in the court premises.
If if I'm not, if PO is fully secured, I say it as of now.
We take
Not
it.
because of agitator's intervention. Entire submission. Your lordship does not want to hear my submission.
Yes, sir, I will hear you,
But
sir.
my submission is, the issue is the PO. The PO I said as of now is also.
My lord,
There is no demolition work that has happened in the PO.
So as of
I'm
now,
saying it
PO
with
is because of
responsibility
the
and on
agitator.
instruction.
We take your word. You let this be on record by whoever is the dean of the hospital or administrator of the hospital. Let him file saying that nothing has been done. You support.
Nothing is in the PO.
Yes. And you can substantiate with photographs. And you can say, and what was the work done? We are with an open mind, sir.
Yes,
But
that's all I'm praying for.
Yes, yes. You should also be disturbed as a citizen of West Bengal. Having been brought and brought up
submissions
here.
are made,
you should
submissions
say.
are made with
Yes, yes.
that also
It should
disturbs.
pain you. It should pain you also. It pains me.
It does pain us. But when incorrect submissions are made, then your lordship doesn't want to hear us, then it's a different
No. It's not that way, sir.
Your
We have
lordship.
been here. We have been.
I am categorically saying the PO is secure as of now.
We will take your word. Take your word. You let an affidavit come on record saying that the PO is safe. CBI is under investigation. If they want, they can controvert. They can also examine. They
have no problem with that. Let them go. Have they made that is the investigating agency. Have they come and said that PO has been demolished?
We have not taken up the issue today. The matter has been listed today because several requests have come by the writ petitioners themselves reporting about this vandalism. So this vandalism, could it have been prevented, is the moot question. Who did it, for what purpose it was did, etc. There's a vast difference between 35 people and 7,000 people. How many entered the hospital? What was the reason to break all facilities in the emergency week? This can never be understood, sir. I don't think so. Such things has occurred in any other part of the country.
I have with me, well, it's just that I cannot show it to your lordship. The amount of resistance the police were putting up and how this vandalism.
It is true, sir. The police are also injured. That's sufficient.
Even a rank of deputy commissioner has got injured. The other officers are also injured. That is when.
So therefore,
but today
is it a failure of the law and order situation?
It is not.
that shows the helplessness of the state police authorities, and that is why we pray for deployment of central paramilitary forces.
Wait.
That is the.
Mr. Bakshi, please.
Mallet.
Therefore, some things should instill confidence in the mind of the court, sir.
If I may, just my point is, this situation is very unfortunate. What is happening? Both sides suffering. I'm a doctor from Calcutta, although I mostly live in USA. But these doctors strike. Now, more patients are dying. Poor patients. These doctors strike. Here is the Supreme Court. All I want, a Supreme Court order. We went.
No, we are going to hear the doctors.
No, it's different thing. It's different thing.
Let him hold these patients, we are on a different.
Dr. Vai, you please file your petition.
He stays in USA. He is so much interested in Calcutta affairs. That's not difficult.
Please,
let us.
You
should first
know you very well.
understand the agony your fraternity is going through.
Totally. I'm with them.
So
but
we will
not
grant
by shutting down hospital. What is happening?
Yes, it has to be. Because
Only one hospital is
today
shut.
Just one. What Supreme
No,
Court
we will not receive anything. You please file your
and
papers.
this matter on Monday has to be mentioned.
Yes,
to be mentioned.
Leave is granted.
leave is granted to file. Please sign.
Your lordship.
Yeah.
Parallelly, a committee may be formed only for, your lordship, the condition of female doctors there who are working, who are studying is precarious. A judicial committee may be created only to suggest what state could take measures to improve the condition. This is required. Not only safety, plus the hygiene, Sexual Harassment Act, which has been brought in as a law. This is also workplace. The basic requirement of a human being is not being given to in any of the government hospital. The public toilets are worse than a gutter. I'm uttering this word, your lordship. As a public citizen, I cannot go to a public hospital for treatment because I do not want to be in such situation. But my state doctors are compelled to work there because they want to study, they want to improve the society by giving them medical facility. So a judicial committee only to suggest, I'm not against the state.
All right, we will consider a prayer at the appropriate.
Sir, my lord, as a matter of fact, my lord, Mr. Banerjee, I don't think he was apprised of that, my lord. My lord, there were two acts, my lord. One was breakage of a wall, if your lordship remember. The first, the second.
No, that we'll go into ground later.
Yes.
Mr. Banerjee has told.
My lord, that was, my lord, as a matter of fact, of the joint, my lord, decision taken by the protesting doctors and the hospital.
See, you bring on record.
What to carry out at that point of time after the CBI was.
The thing
that
is,
is the
Have that.
no,
It was not at the place of occurrence.
just not
in the
adjustment.
that
That is a
that we have heard, Mr. Banerjee.
Just adjusting the place of occurrence.
The place of occurrence is completely secure. Let the affidavit with photographs, etc. come on, no issues. Now, what is the issue is, if suppose this incident which occurred on 14th is repeated in any other institution, what will happen? So, if the police are injured, they are unable to control the mob, then the law and order situation has failed. That's it. That's the bottom line of it.
But may I say this?
Something must be done.
Definitely, my lord, but kindly, my lord, also keeps this in mind, my lord. This kind of, my lord, and may I not say mob, but a demonstration has happened all over Calcutta. That
Not a single one was
It
violent.
only over here that the violence broke out. But there were demonstrations all over, but not only Calcutta.
Bigger in number than this. But everyone was peaceful.
If your lordship falls for your lordship, I cannot stand in the way. There might have been a lapse. But my lord, I am only trying to submit, my lord, that it has not occurred anywhere. These were posted there.
Then why this institution alone?
I'm submitting, my lord, there was, my lord, what we found is, my lord,
আর এই যেদিন এরা কল করলো সেদিন কত
That is what we are saying.
Kindly see them.
But just to repel the contentions of the state, my lord, I would just submit, my lord, that we are in, my lord, possession of video footages to show, my lord, that these demonstrators, these mob, my lord, they were carried, my lord, in lorries. The police granted them free access, my lord. We have the videos. We have referred to those videos also, my lord, in the application. This is nothing but a state-sponsored act, my lord, which was deliberately designed to, my lord, destroy the place of occurrence.
My lord, may I make a small submission? I have already, as your lordship knows, I have already taken out an application, which is unfortunately not, it has not yet been tagged. This is item number 337 of 2024. My lord, I have specifically asked that there needs to be institutional accountability, because at the heart of this entire matter is the question of an utter lack of institutional accountability. And it is unfortunate, my lord, that in 97, Vishakha judgment came. Vishakha came in the context and the backdrop of an infamous gang rape case. And after that, the Vishakha guidelines came, and after several years of struggle, the POSH Act even came into place. Aureliano Fernandez versus State of Goa is a judgment by the Honorable Supreme Court last year, where the Honorable Supreme Court has directed all state, has taken cognizance of the utter failure of institutional mechanism in West Bengal and across the board, all states and union territory administrations, and has asked all states to file a report informing about compliance with POSH mechanism. Unfortunately,
No, Madam Sen, this is a long-term plan. But the current situation is how to prevent such incidents in the near future. Probably tomorrow, day after tomorrow, next week.
my lord, may I?
It has gone beyond the control of the state police.
Indeed, my lord, I agree with your lordship.
7,000 people is what they say.
My lord,
That's what we have listed the matter for.
Yes.
The opportunity, my lord, may I just hand over to your lordship a video, my lord? Your lordship will see the sort of resistance we are facing.
That information, but they cannot control 7,000. You mean assuming that is correct?
How did this come back?
Outside the hospital.
It's not that we didn't have a force. Your Lordship will see the presence of the huge force.
This is a duty of the state intelligence.
After 2 hours.
But the way they are going on.
Means they failed.
These are all after the incident.
The unfortunate police officers, my lord, who are seen in the video are nothing but cannon fodder, my lord. They are victims of a larger conspiracy, my lord. We have videos, my lord, to prove the contrary also. People moving in trucks, my lord, from Kamarhati and from Howrah.
And the police had given them safe passage.
My lord, the MHA, my lord, the Ministry of Home Affairs is the party respondent, my lord.
What
So they-
suggestion would be, my lord, this vandalism should also come under the purview of the CBI investigation as your Lordship directed.
Absolutely.
Because this is related to, my lord, the
Now, in one of the writ petition, the doctor's body was impleted. Which is that case?
That was in item number 5, my lord.
5.
6 today.
6.
5, 6, 6, 6.
Is anybody representing them?
Let us be served with copies. I'm
We have
praying
served.
for that.
We have
I
served.
can't be served with anything.
But he says he has served.
Which one?
335, the doctors have been served through email, madam.
Tickets with what is the number? I know, my lord.
335.
Yeah,
My lord,
Here, my lord, the best option would be, my lord, connect CCTV footages of all government hospitals to the local police stations. My lord, there is judgment of almost one-page judgment, my lord, for the security of the hospitals and their
রিকভারি
which are first.
মেডিকেল এতে যদি হয় এই আইনে বলা আছে যারা ভ্যান্ডাল
পরে আসবে আগে তো
Security of doctors and the hospitals are most important, my lord.
টাইম বাউন্ড ম্যানারে তাহলে কার করা কাউন্ট করো
question of prevention.
এক্স্যাক্টলি ওখানে করা যাবে সব পেশেন্টকে শিফট করে দিয়ে খুলে যাবে
So this is an order passed by the Guwahati High Court. Paragraph 3, my lord. The security of the doctors and the nursing staff is of much importance, my lord. They were protesting peacefully, my lord. The RAF and the police force was attacked them, my lord. That should be secured first.
But did you serve?
Yes, my lord.
The
We have served
doctor's
through
body.
email. We have served through email. My lord, we have filed the affidavit service today, my lord.
There's nobody representing them.
My lord, as of now, we have no interest.
But somebody can inform them
petition.
my lord,
saying that the court would like to hear them as well.
my lord, may I request WPA Pete 337 to be tagged with
Yes,
this?
yes.
And my lord, my prayer is very simple. Let the state submit a report bringing on record what it has done to prevent and prohibit.
No, that Mr. Banerjee has said. He will file an.
Not only.
Please,
But
serve.
the-
We have served the copy. Serve again. We have
5 we have received, but 337 we have not.
337. Who was the petitioner? Please, sir.
339, my lord. On Monday it was filed, my lord. I have mentioned this on bank.
You please serve copies.
Making mistake.
Not served.
339 in the list.
3399.
The issue now is, my lord, repetition, my lord, prevention of
339 is there.
repetition.
339
Service.
339 is there in the list. You please serve. copies on-
May I?
What are you handing over? Your case is in the list, sir. Serve the government pleader.
Not only.
No, you are not to be heard.
Only one thing. My lord, apropos your lordship's order, my lord, the CBI wanted to, my lord, interrogate me in connection and pose me certain questions. My lord, they served on me this notice, my lord, in the evening. My lord, owing to, my lord, the outrage, my lord, outside my house, my lord, the mob violence. Outside my house, my lord, I could not go.
Then you make a
My lord,
prayer.
what I was humbly, my lord, I have made a prayer. I have indicated that I am going to cooperate and I am going to go today. But I thought, my lord, that the petition will be moved and, my lord, an order will. What I was humbly beseeching your lordship is some protection through any agency, my lord, state, central, my lord, to
Yes.
be granted to me.
Wait. If suppose your client is unable to move out of the house, which according to the learned ground pleader may not be correct because he has been given sufficient protection.
No protection to Sandeep Ghosh.
I had.
No, you please give protection so that they will with a
We'll go to this
convoy, he can attend the office of CP.
about 10 H, yes, sir. 10 persons installed nearby with HRFS, which is the high radio frequency unit with them.
All right. He has to.
That is not Shondip. I am appearing for Dr. Shondip Ghosh in person. I mean, the doctor concerned who has been, directed to go on, leave by your lordship's order. He is on leave. He has proceeded on leave.
So, if suppose you find it apprehensive to travel to CBI office to give the statement, state police will provide appropriate escort.
Kindly indicate
that you provide.
Kindly indicate.
No, you make a prayer.
No, I have.
No, we don't want in somebody's writ petition. We can't be issuing this direction. IFSC, we found your client to be a very powerful person.
He is not
power be exercised by himself with the state government. They will provide a pilot escort.
Had he been so powerful, he wouldn't have engaged us. You're engaging me, it shows that he's not powerful.
No.
That shows he is even more powerful.
I will not believe.
Engaging Mr. Bhattacharya shows that he's above the health
Even more.
secretary.
Suppose he has gone to the High Court Legal Services Committee and said that because of all these problems, please give us a panel counsel. Then it's when he is you, then it means he's got all the wherewithal. They will definitely provide you. Sir. We will not. Yes, sir.
The issue has handed.
Sir, Mr. Bhattacharya, ASG is making some. That will be given. Then what we can suggest is, let the special team visit the hospital, because government has taken a clear stand that the place of occurrence is intact. You just assess what is the type of damages which have occurred, etc. Whether how long it will take for the hospital to come back to normal, because the extent of damage is severe. The extent of damage is severe. All life-saving have been
not all,
broken.
Only the rest of the emergency.
No. Emergency is the first place.
I don't have the full instructions about the state of the hospital, but I will not make a submission in court. But all I can say is, I will put it when I'm filing the affidavit. I shall also find out department-wise how many are functional, how many is left untouched without any damage. I shall give that in my affidavit.
How is it relevant? How is it relevant?
No, let your officers visit, sir. They have informed about the incident. Let your investigating team visit. You don't require an order to how you have to proceed with the investigation. Please.
Without taking instruction, my learned friend is making submission. Is it a submission that the PO has been damaged? I want to know.
Yes. The matters have been listed under the caption to be mentioned and shown in the supplementary cost list. The reason being that this court received several representations from the writ petitioners reporting about an incident, an unfortunate incident which occurred in the hospital premises. At about 11:45 p.m. No, at about 12:30 a.m. on 15th of August 2024, when a large mob entered the hospital premises and vandalized the emergency and other departments in the hospital. The learned senior standing counsel appearing for the state would submit that about 7,000 people had gathered, and on account of the unruly situation, several policemen were also injured. And so far as the state police is concerned, they have taken effective steps, but to prevent the mob. But the gathering was so large, there was total chaos, totally a chaotic situation. The learned senior standing council will further submit that the place of occurrence, which is stated to be in the 4th floor of the building, is intact and no damage has been done to the said premises. The learned advocates appearing for the petitioners would submit that indeed there was a attempt to damage a portion of the 4th floor, and after protest, it appears to have been stopped. To assess the so far as the investigation is concerned, the learned additional solicitor general on instruction submits that a special team has been constituted who are proceeding with the matter, and the CBI has also been intimated about the unfortunate incident which took place at the early hours on 15th of August 2024. In our view, the police should place on record the entire sequence of events which ultimately led to the unfortunate incident. That apart, what is more important is that the doctors working in the hospital who are presently presently protesting have to be given adequate protection, or else they would not be in a position to discharge their duties. Though in our earlier order, we had made an appeal to the joint action body of the doctors to reminding them of their pious obligation in treating the patients who come to the government hospital. However, the incident which took place on the early hours on 15th of August 2024 would definitely have an impact on the mindset of the doctors who are presently protesting. In WPAP 335 of 2024, the doctors' body has been implemented and service has been effected through email. We direct the learned advocate for the petitioner to inform the convener or any person responsible, any person who is in charge of the affairs of the joint action group, so that they can be represented before this court on the next hearing date. The CBI is at liberty to visit the hospital premises and make an assessment and proceed with the investigation as they deem appropriate. We direct the appropriate authority of our police authorities as well as the administrator of the hospital to and the person in charge of the hospital to file 2 separate affidavits narrating about the true state of affairs and all matters incidental and connected therewith. Let this affidavit be let advance copy of this affidavit be served on the learned advocates for the writ petitioner and filed before this court on the next hearing date. Listen.
My lord,
The investigating team as constituted by the central CBI shall also file an interim report as regards the progress of the matter.
Your Lordship, one thing
my
could
lord,
be added.
337.
The next date of
Only one
My lord, only one thing, my lord, with regard to the deployment of central paramilitary forces, my lord, considering the situation as of now.
My Lordship, the victims' photographs are circulating in social media. A general guideline, maybe not a guideline, it could be included. It could be included that not to circulate.
Is it so?
To take action.
Yes.
No, the victims' parents are here.
Your Lordship, they
You
may.
don't have a better interest than them.
No, not.
By the friends and others, they are circulating, but probably they do not know the legal implication of
All right. It is submitted by one of the learned advocate appearing for a public interest litigant that the photograph of the victim is being widely circulated in the social media. As the law prohibits the disclosure of the identity of such victim, we request the persons who are known to the victim not to circulate the photographs of the victim and name as well as the name and other identity and details of the victim.
Well, everyone, anybody from disclosing,
Including all citizens.
because everyone, because
It's a guideline by the Supreme Court.
That will be like a John Doe order. That will be like a John Doe order.
There is just a reduction.
Equally, we would request the members of the press and media also to ensure that the identity of the victim or the photograph of the victim shall not be published in any of the reports.
And social media.
That we have.
My lord,
I am a party by name in one of the writ petitions. One sentence.
Yes, in my writ petition. In my writ petition.
my lord, 337 name, 337 may be added.
As your
Tag
lordship,
with this.
Your lordship is keeping this matter on, my lord.
337.
And my lord, I have already served the copies.
You have to ensure that copies are served on the government pleader. During the course of the day, you obtain, acknowledgement.
It is on Sartha. Copy has been served, my lord.
If it is not served, you send one of your colleagues to the government pleader's office. Ensure that it is served.
I will do so.
Then if the government pleader says, yes, it's served, well and
Well,
yes, we have said that.
but your lordship is keeping this matter on
Tuesday.
affidavit to be filed by Tuesday.
No, Tuesday you file it in court. By Monday evening, you circulate soft copies.
Well,
If government pleader wants, he will do it.
kindly forgives me, kindly me not scolds me, do whatever. Kindly records my submission that I have made this submission, nothing.
As of now, we are not.
Very well, as your lordship.
Let him, as you rightly said, your client is cooperating. He will cooperate. State will provide him police pilot and escort. Take him there.
Pilot, no.
We don't know.
Sir, he is not so powerful that he is entitled to a pilot.
In case, one more option. In case he still has the fear psychosis, to invite CBI officers to his residence.
Yes.
They can also see how well you have maintained your residence.
Well, I have a humble appeal that may it be Wednesday instead of Tuesday. Tuesday, before the Supreme Court matter is fixed.
All right, Wednesday.
Well, deeply.
Wednesday.
Well, yes, we are agreeable. Let the CBI officer visit my house.
So the first is, see,
Well, I just
wait. If the CBI officers come there, there will be a lot of the other commotion. Public will there. The local auto rickshaw drivers will inform.
very well.
And the neighbors also, their perception of the entire situation will be different. Police has come.
Very.
Me amazed.
So that will damage.
With the live telecast, everybody.
But not him. But
It
his
is
family.
difficult for us.
His family.
Family, yes, his family is more trouble.
That's it.
He has a 5-year-old kid.
If these persons visit them, obviously it won't be in
That
uniform.
will be. I'll make an endeavor to not.
You handle it.
Hospital authorities to be file any affidavit.
Supplementary affidavit. Sir, supplementary, madam. Supplementary affidavit. Have you served copy?
When? No, sir.
Oh.
But I'm sitting.
My lord, may I humbly beseech your lordship, my lord, with regard to my lord?
Yes, we'll go stage by stage, Mr. Bakshi. Wait.
My lord, yes, man. My lord, but consider the aspect of the next date of hearing, my lord. The deployment of central forces.
A supplementary affidavit has been filed by the writ petitioner in WPAP 339 of 2024, which is taken on record, and the learned advocate for the petitioner is directed to serve copies on the respondents, more particularly in the office of the learned government pleader.
All by today.
By 3 p.m. today. Very good. 3:30 p.m. today.
I'm there, but I still.
No, by today, as long as it's given by today, but we are all there.
But I'm here always, sir.
Well, a copy may be given to the hospital authority.
Oh, yes, our respondents and in particular to the office of the learned. All respondents.
Very good.
What is this? There is wait, cut off. Scissors. CBI is given some sealed cover. It is handed over to the Registrar General. Oh, this is the copy of the FIR registered by CBI along with the copy of the court order. The CBI had submitted a sealed cover addressed to the Registrar General of this court. The cover was placed before us today and it was opened, and it contains the first information report registered by CBI dated 13/8/2024. Along with the copy of the order passed in these petitions dated 13/8/2024. Copy of the first information report registered by the Tala police station.
That is done by me.
No, we are just saying enclosures.
Case number 160.
Copy of the complaint dated 9/8/2024, which is in regional language. The FIR and the annexures be kept on record. Cover also. So Wednesday it will come.
But since my lords are making it returnable on Wednesday, but may I just humbly suggest this, my lord, that since my lords are also exploring, my lords, about protecting these particular hospitals, and since the Ministry of Home Affairs is already a party respondent, on the next day, my lord, if they can also come back with their inputs as regards deployment of central forces, my lord, in the event, my lord, the court also desires.
At this stage, we don't want to make any observation. Let
Very
this
good.
observation be on record. Mr.
Very
Banerjee, yes, sir. On Wednesday we will see.
My lord.
Yes.
My lord, will your lordship be kind enough to grant me leave in this matter, my lord, on the self-same cause of action to file it and come on to Wednesday, my lord? I will serve the copy to the London Government of Leader's office by today, my lord.
Now itself, right and now.
Also,
Yours also.
My lordship.
All of you file, don't derail the entire matter. That's it.
No, man.
And they will say affidavit in opposition, reply, exception, report.
Today or else I will withdraw, my lord.
And
by today.
By then I will retire.
We will file our affidavit reports in the form of affidavit, Your Lordship, not deal with all these hundreds of petitions.
Almost the allegations are identical in all.
Yes,
But if we have to deal with them, then
No.
we'll file one comprehensive affidavit on the factual.
Called by your lordship.
Chronologically, as you were
Yes.
chronologically.
Yes, we shall do it.
That would
What that?
My lordship, I am a Konika ready to welcome.
So we will take up original side matter. By then they will organize the files. We'll go back for 5 minutes and then this one also.
হয়ে যায় তখন আমরা
15 minutes.
কোনটা কোথায় আমি ওটা আপনাদের ঘাড়ে ছিল না কি মেনশন করেছি জানি না
আর বুঝবে আমরা বসবে তো এবার চুলটা চেঞ্জ করতে লাগে চক্র করছে না আচ্ছা এটা দাদা জামাটা কথা হবে পরে হয়ে যাবে আগে লিস্টে আসুক তারপর দেখ না 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 আগের দিনে কোনো অর্ডারে কোনো ডাইরেকশন ছিল বললে হবে না খুলে দাও দড়ি খুলে দাও এই যে এখানে আছে এইগুলো এটা কি আছে এমআরস মাইনিং আচ্ছা এমআরস পিচ না ভালো হয়েছে বুঝি না ছড়ালে কেসটা আমরা সিনিয়র তো আসেনি কোর্টে বাড়িতে বসে আছে বলছে তো কোর্ট যখন জাজমেন্ট গুলো বলেনি কোনো দেখি স্যার কি বলে এখন ব্যাপারটা হচ্ছে সিনিয়র নেই সিনিয়র তো ওখানে বসে আছে এই সমস্যা
কখন বসবে আবার স্যার জানাবেন আমি আছি
হ্যাঁ হ্যাঁ স্যার 5 এখানে আছে রেখে দাও তো উনি হচ্ছে
তুমি মেনশনে হ্যাঁ এইটাতে কারেক্ট আমি আজকে মেনশনই করতাম কারেকশনের জন্য চলে আসছে এই
আমজা যে জাজমেন্টটা নিয়ে ওর সঙ্গে বেঁধে রাখো যেটা কোন জাজমেন্ট গুলো দিয়েছিলাম দেখি জাজমেন্ট গুলো দিয়েছিলাম দেখি
যখন বলে দেবে এখন বলো না এখন হবে না এখন অরিজিনাল সাইড হবে নেবে এটা
আজকেরটা মানে মুখ কার সঙ্গে কথা বলতে হবে
সেকশন 31 এর সঙ্গে কথা এটা সেকশন 31 এর সঙ্গে
আবার পরে নেক্সট ডে থেকে বললো একসঙ্গে ট্যাগ করবে
তো ওটা আজকে অ্যাপিয়ারেন্স দেওয়া যাবে না আগের দিনে কিন্তু আপনারা দেন যারা ওখানে বসেছিল
আরে আগের দিন আমি চেম্বারে গিয়ে জিজ্ঞেস করেছি যে আর কানেক্টেড ফাইল তো বলো না ওটা এখন থাক কি বলবো আমি নাম নিয়ে গিয়ে চেম্বারে বলেছি এই কানেক্টেড ফাইল গুলো কি করবো দুপুরে ওটা গুলো এখন থাক যখন বললাম
ছিয়াশি আছে এটা হচ্ছে হামচার গ্রুপটা কোথায় এটা হামচার না 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 বললাম অনলাইনে দিয়ে দেবে কিছু হলে কিছু হলে আসবো
মানে
এইটা জন্য এটা ইয়ে অনুরাগ
অর্ডারে লিখে দিয়ে
করেছে এটা আপনার চেক
স্পেশাল কেস
আর একবার বলছি যে মেনশনের ব্যাপার যেটা বললাম ওটা কি পার্টিকুলার কোনো ডেটে হয় যে কোনো দিন
না শুধু লিভ ইউজুয়াল কোর্স সেদিনকে এমনি দেখছেন ইউজুয়াল কোর্স আছে ইউজুয়াল কোর্স গোবিন্দ দাস কোনো স্পেশাল গোবিন্দ দাস পড়বে
বুধবারে লিস্টে দিয়ে দেবে সব
তাহলে বুঝতে হবে ডেটটা দিতে পারে ইভেন ডেটটা দিতে বুঝতে
আগে আগে
বৃহস্পতিবার আসবে
चालानটা আছে ঠিক আছে আমচা কোথায় আছে আমচাটা এই বাটটা রেখে দেন
কেউ না কেউ নিয়ে গেছে আমার
না এটা গোবিন্দ দাস তো মামলা কি করে আরে এগুলো করবে না খুশিতে কি বলে আর জানা
গেল বুধবার 21 তারিখ
আসেনি তো
21 তারিখ 21
কি করবে দাদাকে ডাকবো না অনলাইনটা করবো না কাজ গোবিন্দ দাস গোবিন্দ দাস করবো না শুধু আদেও কতগুলো ম্যাটার এগুলো মধ্যে থাকবে না সব করানো ওরা হয়নি আমার গোবিন্দ দাস করে দিয়ে খুশিতে
হবে না টাইম হয়ে যায় আর আদার সাইডে সব বড় যাবতীয় লয়ার আছে বাই চান্স যেটা অর্ডার করে চলে যায় প্রবলেমে পড়ে যাবে 4 to 6 লিখে দিতে হবে না আলাদা আলাদা লিখতে হবে
4 to 6 মাস
4 to 4 to 6 এই যে গনি সাইনাস আর এ কে ইমপ্যাক্টস এই আলাদা আলাদা লিখতে হবে না তুমি একটা লিখে দিলে হবে তো কাস্টম সাথে ওটা লিখে দিয়েছি আর তুমি লেখা লিখতে হবে না তো আর কি কোনটা করতে বললাম করে দিয়েছি আমি ওইটা ঝামেলাটা মিটে গেলাম টেনশন ফিল মুক্ত ওখানে সব বড় বড় বাপিদারা আছে বাংলাটাতে একটা অর্ডার ফর্ডার করে নিয়ে গেলে মুশকিল হয়ে যাবে সাথে হিয়ারিং চলছে অর্ডার দিচ্ছে হ্যাঁ তাহলে আলাদা আলাদা করে তাহলে একটা অর্ডারের মধ্যে ঢুকিয়ে দেবে স্যার ওটার মধ্যে কেটে দাও 26 কেটে দাও বলো আমি লিখে দিচ্ছি বলো তুমি বাকিগুলো লেখো যেগুলো আছে আইটেম নাম্বার 5 তাই তো আমি লিখে দিচ্ছি দাঁড়াও সিপি অ্যাডভোকেট তপন মোহন লিখে দিচ্ছি আমি করে দিয়েছি গণি 4 সাইনাস হচ্ছে 5 একে ইমপ্যাক্স 6 দাঁড়াও অ্যাডভোকেট ফর দা রেসপন্ডেন্টস ফর দা রেসপন্ডেন্ট হ্যাঁ দাঁড়াও এটা কি লিখবো অথরিটি দাঁড়াও 5 লিখে দিচ্ছি কাগজ আছে খালি আইটেম নাম্বার 6 তাই তো 6 তো 4 5 6 হ্যাঁ পনেরোটা একসঙ্গে লিখবো এটা 4 5 6 আলাদা আলাদা করে লিখে দিতাম দাও এটা লিখে নিই আর
তপন ভঞ্জ। ওটা অন আছে তোমার দেখো তো কত হচ্ছে দেখো তো ওখানে এসে তারপর এটা হচ্ছে ফর দ্য রেসপন্ডেন্ট।
স্যার কি করবে অনলাইন বলেছে?
সেটা তো অনলাইনে ঢুকে আছে একটা মামলা 8 নম্বর করে একটা মামলা আছে 9 নম্বর আইটেম। আজকে মামলাটা লিস্টে আসার কথা না হট করে চলে এসেছে 9 নম্বর করে 8 নম্বর আইটেম আজকে চলে এসেছে তা ওখানে তারপর তো লয়াররা আছে যদি একটা অর্ডার পাস করে চলে যায় ওখানে আমি কোনো থাকছে এই কারণে ওটা আজকে হবে না টাইম হয়ে যাবে তারপর এখানে ঢুকে যাবে ঠিক আছে
এখানে তো বসেই নিয়ে
না না তো ঢুকে যাবে তো অনলাইনে আছে আপনি কথা বলে নিন না ফোন করে একবার একটু ফোন করে নিন না কি অবস্থা আছে জেনে নিন একবার
রেসপন্ডেন্ট দিচ্ছ না
হ্যাঁ কোনটা অ্যাপ্লিকেন্ট হয়ে তোর বা রেসপন্ডেন্ট দিতে দিতে দাদা তো এবারে কেটে কেটে অ্যাপ্লিকেন্ট করে দাও অ্যাপ্লিকেন্ট করে দাও হ্যাঁ আমার মাথাও সারা কাজ করছে না দোষ বারোটা দেখে নিও ঠিক আছে নাকি আরে কাস্টম কত করে লিখে দিলে তো হয়ে যায় ফর দ্য অ্যাপ্লিকেন্ট লিখে দেবো কাস্টম দেবো না আরে কাস্টম অ্যাপ্লিকেন্ট দিতে হবে না কাস্টম দেখা দেবো নেই যাও অ্যাপ্লিকেন্ট লিখে দিয়েছি ধরো এই যে 6 এটা দেখে নিও চেক দেখে নাও দেখে নাও দেখে নাও 4 5 6 এটা করে কাস্টম কেটে দাও আর কি আছে কোনো জায়গাটা আমার কার হয়ে অ্যাপ্লিকেন্ট হয়ে হ্যাঁ সবই অ্যাপ্লিকেন্ট হ্যাঁ ঠিক কত নম্বর জন্য এটা 8 নম্বর অনুবাদ চালান হচ্ছে 3 সবগুলো একসঙ্গে নাকি আলাদা আলাদা লিখবো তো একটা অর্ডারের মধ্যে সব নাম ঢুকে যাবে না তো না আলাদা আলাদা দেওয়াই ভালো তখন হট করে যদি একটার মধ্যে অর্ডার করে দিতে তাহলে মুশকিল হয়ে যাবে কিন্তু অর্ডার যেভাবে দেবে সেভাবে তো হবে অর্ডার যদি সবগুলো মিলে একটা করে দেয় তাহলে তো একটাই অর্ডার হবে আচ্ছা এটা আলাদা করে লেখো এটা হচ্ছে কৌশিক দে হ্যাঁ ভালো ফর দ্য অ্যাপ্লিকেন্ট তাই তো হ্যাঁ লিখে দিয়েছি ফর দ্য অ্যাপ্লিকেন্ট কত হচ্ছে আমার টেনশন আছে বা আজকে কোনো অর্ডার পাস করে না
Original side Delhi is matter item number 2 for the appellant petition. This is my affidavit of service. The brief facts, my lord, which has led to the appellant petitioner to file a writ petition, which has been dismissed, for which, my lord, the appellant petitioner before your lordship, is that the appellant number 1 and appellant number 2 are husband and wife. They have purchased a health insurance policy commonly called floater plan in the year 2019. Initially, that policy was of 2 years, 19 to 21. Thereafter, it was extended for 21-22, then 22-23. Now, my lord, in the year 2023, on 8th of April 2023, this appellant number 1 was admitted for coronary bypass surgery. My lord, he was admitted, bill was raised of about 3 lakhs and odd. The claim was made. The claim was rejected by an email dated 1st June 2023 by the respondent number 2, stating that in the year 2018, that is prior to the commencement of the policy, you had a total bilateral hip replacement, for which we cannot honor your claim. Now, my lord, this policy which this appellant number 1 has taken is through online mode. My lord, there's a categorical statement made that entire facts, including the disclosure of this earlier operation, was being disclosed. Now, my lord, thereafter, my lord, in the year 2022, this appellant number 1 had a psychotic eye treatment. In course of that treatment also, my lord, this treatment of 2018 was disclosed. The medical document to that effect has been annexed, my lord. Now, my lord, the complaint was made with the respondent number 1. The respondent number 1 relying on one tally verification call, my lord, which was neither handed over to me, not shown to me. My lord, rejected my claim. Now I beseech your lordship to, my lord, I'll show your lordship the order passed by the ombudsman, my lord. Now that is at page number 86. It starts from 86, my lord. The ordering portion is at page number 87, last paragraph. It is observed from the contention of both the parties and on perusal of the documents, the complainant had not disclosed the material facts about the health condition of the insured person. Even in the absence of any proposal form, the tele-verification call also does not evidence declaration by the insured. The insurance policy, being a contract of utmost good faith, is based on the details given by the insured to the insurer, which makes the risks acceptable for the insurer. Non-disclosure is a violation of the basic principle of the insurance and terms and conditions of the policy. Taking into consideration the facts and circumstances of the case, the contention made by the parties, and on perusal of the documents on record, it is observed that the complainant had not disclosed his medical history at the time of taking policy, nor declared the same during the tele-verification call, which is violation of the policy terms and condition and basic principle of the insurance contract. Hence, the repudiation of the claim made by the respondent is justified and the complainant is dismissed without any relief to the complainant. Now, I beseech your lordship to take one medical document of 2022 of the respondent of the appellant number 1, wherein the claim was honored, and also a prescription wherein the treatment of 2018 was also disclosed, my lord. But first, I'll take your lordship to page number 59. My lord will find this document has been issued by the respondent number 2 addressed to Calcutta Medical Research Institute. My lord will find date 5th August 2022. Now, patient name is the appellant number 1. The treatment is ischemic optic neuro unspecified eye. Hospitalization duration 26 July 2022 to 30th July 2022. Now, they have honored this claim. Now, I beseech your lordship to kindly turn up to page number 111. This is a document, my lord.
Page
111, your lordship. 111. 111.
Yes. It's folded, annexure E.
Annexure F, your lordship. My lord, with regard to same neuropathic eye treatment, my lord, issued by the CMRI in favor of Mr. Pralay Shankar Dhar, my lord will find in the bottom THR 2018. Total hip replacement 2018. So my contention is that, my lord, this policy.
No. The case is, did you, under the appropriate column, while applying for the insurance, because this is online mode.
My lord.
Did you disclose?
It was disclosed, my lord.
You show that form.
My lord, since this was being the online, my lord, the policy was purchased through tele-verification call. But there was no written proposal form. And my lord, to that effect, there is a regulation called Insurance Regulatory and Development Authority of India. My lord, may I hand over a copy of the regulation. I'm placing reliance on Regulation 8.2. Now, there was no written proposal form. The policy was purchased through online mode through tele-verification. I have categorically made statement that all disclosure was made. Even I have offered myself that you check whatever you want to before issuance of policy. My lord will kindly take up Regulation 8.2. Now, running page
19.
Running page 19, your lordship. In case of marine insurance cover or other insurance cover, where a proposal form is not used, my lord, this is my case.
The insurer shall record the information obtained orally or in writing electronically and confirm it within a period of 15 days thereof with the prospect and incorporate the information in its cover note of policy. Where the insurer claims that the prospect suppressed any material information or provided misleading or false information on any matter material to grant of a cover, then the onus of proof rests with the insurer only in respect of any information not so recorded. Now, I beseech your lordship to kindly also take the transcript, how they have recorded my voice, my lord, at the time of selling the policy. So that is also totally observed. My lord will kindly take a page 48.
48.
My lord. Running page 48. My lord, this is the first insurance policy I've told your lordship I purchased in 2019. My lord will find date, period of insurance. On the top right hand side corner, 2021. Now, lordship will kindly take up the transcript portion. That is at page number 49. Now, my lord will find introduction. Good morning, sir and madam. Am I speaking to Mr. Pralay Shankar Dhar on phone number so and so? I am Kundan Kumar and AV certificate number so and so of HDFC Bank and corporate agency. This call is regarding my health insurance Silver Smart. Customer response okay. This cannot be an okay. I will be either be saying good morning or something like that. It is only okay, okay, yes, okay, yes. So, my lord, this is also observed. Now, my lord, I am asking to myself. Now, taking it.
Now, you come to the column pre-existing declaration.
Yes, my lord, pre-existing declaration.
What was your answer?
Have
any of the persons proposed to be insured ever suffered from, currently suffering from any disease, ailment, medical condition, illness, accident or injury?
The answer is okay. It cannot be okay, my lord.
How it can be okay? That's what the learned judge says.
No, but it's this is their recording, my lord. This is the insurance company is what they have recorded. And my lord, I am asking to myself, insurance cover, my lords know health insurance specially. It is being, my lord, renewed year to year. This first policy started in 2019. 2021, it lapses, my lord. Further, I have renewed in 2021, which continued to 2022.
Suppose,
my lord,
on this televerification, if he had mentioned that he is a diabetic, he has undergone both hip surgery. Obviously, the insurer will not record okay.
No, my lord will kindly also see the answers yes, no, okay. My lord, they have not recorded anything what I have stated.
We can't test all those things in a written.
No, my lord, that's true. My lord, I'm not on this. Only my contention is
but,
that.
Probably if you had gone to a civil forum.
No, my lord, my contention is that they have relied on televerification call. My lord, in the.
And moreover, this is a private insurance company.
And my order which I have challenged is of insurance ombudsman. My lord, guided by judgment, my lord, which I will be showing. My lord, my first contention is the violation of the principle of natural justice. My lord, regulation 15 of the insurance ombudsman rule, my lord, requires the respondent number 1, who is the insurance ombudsman, to act fairly and equitably, my lord. My lord, may I place regulation 15, my lord. The ombudsman may, if he deems fit, allow the complaint to adopt a procedure other than the sub-rule 1 or sub-rule 2 of rule 14 in making a complaint. My lord, I'm directly jumping into, my lord, rule 4, my lord. The ombudsman shall dispose of a complaint after giving the parties to the dispute a reasonable opportunity of being heard. Now, there's a gross principle of natural justice. A document, a material has been relied upon by the respondent number 1 being the televerification call, which was neither shown, neither the copy was provided. My lord, regulation 17 says that the award should be passed based on the pleading and evidence based on record. May I hand over a book, my lord? My lord, the insurance company would have refused to renew my policy in the year 2023.
No, the earlier policy was a life insurance policy.
My lord?
The earlier policy was a life insurance policy.
No, earlier policy was the health insurance. Health insurance, my lord.
No, the learned judge has recorded.
No, my lord,
the contention, page 106, second paragraph.
My lord, may.
Has recorded the contention of the insurance company. Points out that the same pertains only to.
My lord is reading internal page 2 of the order.
3.
Internal page 3, my lord. learned counsel appearance for the insurance company. No, my lord, the reason why this has been stated, initially I have relied upon section 45 of the Insurance Act, which states that the policy cannot be called into any question, even if there is a misstatement after a period of 2 years from the issuance of that policy. That is section 45 of the Insurance Act says. Now, my lord, this was a contention that section 45 of the Insurance Act only applies to life insurance policy and not to health insurance. Now, this is the health insurance policy, my lord. My lord, I concede, my lord, to that legal proposition that has also been, my lord, upheld by the Honorable Supreme Court, that the section 45 will only apply to the life insurance policy. Now, my lord, kindly visualize the situation, my lord. 2019, I purchased a policy. Twice they have honored the claim. In course of honoring my claim, I have disclosed, even at the time of purchase, I have disclosed that I have a total hip replacement policy, replacement in the year 2018, my lord. That is, medical document is there.
Yeah, assuming it was disclosed or non-disclosed,
My lord.
this is a fresh policy.
No, this is not the fresh
All right, renewal.
No, continuation.
But then subsequently they come to know that this particular pre-existing sickness or pre-existing health condition was not.
My lord, that is my argument. In the year 2000, not subsequently, my lord, in the year 2022, in case of my treatment of ischemic naturopathic eye treatment, I have annexed the document, my lord, which I have shown in page 111. So total hip replacement tooth. And my lord, it's a kind of treatment, my lord, no one can suppress. Even in X-ray machine or in USG, if I go, because various iron parts are there, my lord.
But then he has not subjected himself to a medical examination before the policy was
My lord,
issued.
that I have categorically stated, my lord, will kindly take a page number.
This is the risk you undergo,
No, my lord,
undertake when you have a tele policy.
my lord will kindly appreciate regulation 8.2. My lord, that is the reason, my lord, these regulations are being framed that when there is no written insurance policy, the onus of separation and materials.
No, assuming there was a, they honored an earlier claim.
My lord.
There cannot be any.
My lord, honor of, that's true, my lord. But in course of the honoring of claim, had I been the bad intention or there was no mens rea, I would have not disclosed, my lord, these facts. And further, if my lord will see regulation 8.2, it is a contention made at their instance that I have made separation. Lord, onus is upon them. Number 3, my lord, the insurance ombudsman had relied upon one tally verification call. My lord, what I have stated, what I have not stated, and I've also shown, my lord, the transcript, which is also absurd, my lord. My lord will appreciate regulation 17 at the time of passing the award. The insurance ombudsman is required to rely upon the concise statement and the evidence. But no evidence was there, my lord. Even if I don't ask, my lord, they are required to provide me the copy. My lord, I am a senior citizen, my lord. Right from 2019, they are taking money from me. And my 2023, they are stating that in 2018, you have got a treatment of total hip replacement. And my lord will also appreciate the treatment with regard to 2023 was coronary artery, having no connection with total hip replacement, my lord.
You can't say, no? That is up to the insurer. That you can't say.
Well, only contention which I am trying to and harness upon your lordship that I have never suppressed, nor there was any mens rea. Guilty mind, my lord. Had there been any guilty mind, the subsequent treatment and the medical document would not have stated, my lord, that there was a total hip replacement. They could not have renewed my policy. Why they have chosen to renew the policy? In the year 2022, they have further renewed my policy, knowing very well that THR operation was there. So second contention, my lord will also appreciate the language of regulation 8.2. They have chosen to issue me a policy without a proposal form. Not only mine, they have also, my lord, cancelled the entire policy, my lord, of my wife. Well, apparently, my lord, there is a violation.
If you had taken such a health medical insurance with any public sector insurance company,
my lord,
they would not have granted the policy without a full-fledged medical examination by
my
their
lord.
panel doctor.
No, that is, my lord, no, that is for the, my lord will kindly appreciate, this is for the insurance company for medical tests. When there's a categorical statement made by the applicant in the writ petition that I have offered them to, at the time of purchasing policy, that whatever test you want to, you can do. Further, my lord, I have a categorical statement that this total hip replacement, which I have undergone in the year 2018, was also disclosed to them. Now, my lord, the third point is that even in the course of my treatment in the year 2009-20.
When this question and answers, no, where is it? Page 58.
My lord. Page 49, your lord.
49.
My lord. Now that learned single judge, my lord, has stated that it's an absurd, my lord. He is not relying upon this. My lord,
No,
because-
no.
My lord,
If suppose this was given to you at that point of time, along with the policy,
my lord.
you should have
I have
pointed
to, but
out-
my cause of action had arose, my lord, in the year 2000.
you should have pointed out, this is wrong recording. It's not okay.
My lord.
You please change. This is what I have said.
My lord, that's true, my lord, but my cause of action for the writ petition has already arose in the year 2000.
Maybe, but then
2023. By that time, my lord, this policy was not there because that was renewed, my lord. This transcript was not there. My lord will kindly appreciate, my lord, a senior citizen making payments since last. Further, there was no guilty mind or menshria. In 2022, he had undergone the treatment of
what is it?
neuropathy unspecified.
Purely a contract, sir.
It's a contract, but my lord, only also kindly consider.
Yeah, because but for the order passed by the ombudsman, writ petition was not maintainable.
Well, writ petition, but there is a prima facie violation of the principle of natural justice, my lord. Writ petition ought to have been maintained.
Expect the ombudsman to write a judgment.
Well, that's true, but he's relying upon the tele-verification call. My lord will also appreciate regulations 17, my lord, which I've handed over to your lordship, that the award should be passed based on the pleading and the evidence.
The reasoning given by the learned judge is appropriate.
My lord will kindly contention, my lord will kindly record my lord will kindly appreciate, my lord, 2019, my lord, I purchased the policy treatment where there I've disclosed everything. This insurance company ought to have declined for the renewable. Why they have renewed, even knowing that there was a THR 18. Let's take it, my lord, I have not disclosed, I have suppressed everything. Then, my lord, in the year 2022, when I had undergone this ischemic optic neuropathy unspecified eye treatment, they have honored the claim. Medical document also shows. Thereafter, my second term expires. Thirdly, they chosen to renew it. And my lord will also consider regulation 8.2, my lord. My lord, onus is totally upon them to show that I have suppressed when there is no proposal form.
Page 80 is the
Page
80.
80, lordship.
That's where they repudiate. What do they say?
My lord will
Once policy is cancelled, claim is repudiated due to non-disclosure.
Hello, it's at page 80. Yes, page 80.
And concealment of fact under section D4 of the policy terms and conditions.
They have stated, as per the document submitted, patients was admitted on 8th April 2023 for the treatment of coronary artery disease. Patient has history of bilateral total hip replacement, 2018. Before the first inception date of the policy, 1st 12, 2019. Hence, the policy is cancelled and the claim is repudiated due to non-disclosure. The point which they have taken is that I have undergone a total hip replacement policy in the year 2018, my lord. That is prior to the inception of the policy. For last 4 years, they are renewing the policy. They are honoring the claim. In course of treatment, they very well knew that THR 18 was done in the year 2018. Then I'm asking to myself why they have chosen to further extend it in the year 2020-23. When there's a categorical statement that I have all through disclosed everything. And in course of hearing before the respondent number 1, documents, materials were being relied, neither discuss nothing. I have been served with this order that it has been rejected because one tele-verification call. I don't know what tele-verification call was there.
Sorry, sir. Please come. This intra-court appeal by the writ petitioner is directed against the order dated 1st May 2024 in WPO 308 of 2024. The appellant writ petitioners challenge the order passed by the insurance ombudsman, who affirmed the order passed by the respondent private insurance company repudiating the insurance claim made by the first appellant. The learned advocate appearing for the appellant would vehemently contend that the order passed by the ombudsman is wholly untenable without taking into the factual situation.
My lord, may consider to remand it to the ombudsman, my lord.
Factual contention.
What verification calls, my lord?
And the order is in violation of the principles of natural justice. The respondent insurance company before the learned single bench contended that The repudiation of the policy was on account of non-disclosure of the double hip replacement surgery done on the first appellant during the year 2018. The contention of the appellant was that the policy was renewed once, and in between, the appellant made a claim for undergoing eye surgery, which was approved, and amount was sanctioned. Further, it is submitted that reliance has been placed on Regulation 8 within bracket 2 of the Insurance Regulatory and Development Authority of India. Regulation 8 within bracket 2 of the Insurance Regulatory Development Authority of India within bracket protection of policyholders' interests bracket close Regulation 2017. The learned single bench had extensively considered the factual matrix and also dealt with the effect of Regulation 8 within bracket 2 of the Act. In our view, the learned Red Court also took note of the transcript of the voice conversation between the parties and was of the view that the answer okay for one of the questions as regards the pre-existing health condition was not an appropriate answer. That apart, the issue that the insurer had honored two policies previously was also considered and rightly held that it cannot be elevated to the high status of acquiescence or waiver on the part of the insurer, since an act of waiver constitutes an act which is done with full knowledge of fact which is sought to be waived. The reference was made to the decision of the Honorable Supreme Court in the case of Satwant Kaur Sandhu versus New India Assurance Company Limited, 2009 ATCC 316. It is there in page 106. And the learned single bench noted paragraph 16 of the said judgment, wherein the Honorable Supreme Court held that the materiality of the fact which is alleged to be suppressed depends not on the present claim or the nature of the same, but on whether the suppression had a bearing on the insurer being agreeable to accept the risk at all or in fixing the premium for the insurance policy. With regard to the double hip replacement surgery performed on the first appellant in the year 2019, the learned single bench was right in observing that this is undoubtedly a matter of serious importance, since the fixation of premium and/or the decision of the insurer to accept the policy in the first place would directly be linked with such disclosure. The effect of Regulation 2(8) within bracket 2 was also considered, and it was held that the and held that on account of suppression of the material facts, the petitioners would not be entitled to any equitable relief in a writ petition. Thus, we find the reasoning given by the learned single bench are just and proper and does not call for any interference. For the above reason, the appeal stands dismissed.
I'm grateful.
Item number 3.
This is my lord. It's relating to the my lord Tram.
My lord, we had brought it to your lordship's notice that in spite of your lordship's order, they were bituminizing the existing tram tracks.
That was some newspaper report.
Yes, my lord, we have also affirmed a contempt application. Now the problem is that lordship is hearing two matters. One in the appellate side, other is on the original side where I am appearing. The order restraining them from further bituminization has been passed by your lordship in the appellate side matter.
So
My
we
lord,
call for that also.
yes, my lord, when we go to file this contempt application in our matter, bringing the notice of the court, my lord, department is not accepting the contempt
Because the
application
order was not passed here.
in this one. But
You file it in the appellate side matter.
I cannot file because there I am not the petitioner. Because there are judgments to that effect that anyone can come up before the court and this may
What
be.
is the response of the state?
Mr. Siddiqui is the counsel engaged in the matter, but whatever my instructions are, that we are going to keep a portion of the tracks for trams, and that is the instructions. We are going to file an application by next week. To the extent which
In which case you are going to file in the other?
in the original.
Original. You file an affidavit?
And in the meantime, I take this number.
Yes, we kindly keeps it after 2 weeks. By next week, we'll be filing this application and everything can be brought on record.
Your oral instruction is you are not going to remove the tracks?
No, not to the extent to in a particular portion the trams will apply, but not for the entirety of the portion. Entirety.
Then you have to get the order modified.
Yes, that is the application.
Then until then you don't do anything.
I am not.
They are filing a contempt petition.
Lordship kindly keeps it on. Then next week by this.
And have you got the order passed in the appellate side matter?
Yes, yes.
Where?
That is contempt petition there.
You give a copy of that order.
Petition there.
Today, your lordship.
What is this?
The affirm petition where the order is annexed.
That order is sufficient.
I think it will be there in the appellate side
running
matter.
in the list today.
Yes.
Order dated 8th of May.
8th May 2023. WPA 214.
This matter, please take down, sir, as was mentioned before this court for a early hearing, and accordingly the matter is listed. According both the matters are listed in WPAP 214 of 2023.
Paragraph 6.
Which was filed in the appellate side. This court had passed an order on 8/5/2023, making it clear that the respondents shall not carry out further bituminizing or removing the tram tracks, and nothing should be done till a decision is taken by this court in the writ petition. The learned advocate appearing for the petitioner in WPOP 12 of 2023 submits that this order is sought to be violated by the respondents, and news reports are widely circulated that the tram tracks are to be removed and bituminization process is to be carried on. In fact, the petitioner in WPOP 12 of 2022 proposed to file a contempt petition, but however the same could not be presented in the department since the interim order was passed in WPA P 214 of 2023, which was filed in the appellate side. The learned advocate appearing for the respondents submitted that the respondents are in the process of filing an appropriate application, and the oral instruction given is that the entire tram tracks are not proposed to be removed, but they will be made to ply in specified areas. As long as the order dated 8/5/2023 has not been varied or modified, the respondents are bound to comply with the same in its letter and spirit. In the event there is violation, then the respondents are exposing themselves to action under the Contempt of Courts Act. Therefore, the respondents are directed to strictly comply with the order dated 8/5/2023 in WPA P 214 of 2023. The respondents are at liberty to file appropriate application if they so desire.
My lord, may I seek leave to file this in the original site, my lord?
No,
Leave may be
not
granted.
required. You have said so.
My lord, we have affirmed, my lord, it is ready, my lord. We just
Technically, it is not maintainable. No, we are hearing you. We are here. Don't worry. Next. Next.
Item number 4.
My lord, in item number 4, 5, and 6, my lord.
Hmm.
In item number 4, 5, and 6, my lord, I am for the appellant lordship. I'm not well. That's the reason I could not come to court. If your lordship kindly takes up this matter on the next day, my lord.
All right. At the request of the learned advocate, the appellant. 4, 5, and 6.
4, 5.
4, 5, and 6. Now, there are other matters also. May I mention right now or at the time of call, if your lordship so directs?
Well, item number 11, 12 also, my learned
He is
friend
not
is-
well, Mr.
Oh, so 11, 12 also, I don't think he will be doing the matter today.
All right. 11 and 12 also.
11, 12,
11, 12, and 13. 11 to 10, 10, 11, 12, 13. Up to 17, my lord. Up to 17. 10 to 17.
All right. Let it remain in the list. Why we should adjourn? Not today.
My
we'll
lord.
Today, not today, only make it not today.
We'll say it not today. Subject to your convenience, we'll take it up.
Yes. 14 to 10 to 17, total, not today. 10 to 17, Mr. Dey is appearing.
He is not well.
10 to 24 to 30, 10 to 17.
All right. Any matter where both sides are ready?
Both sides are ready. 24.
My lord, 24 is also, he is appearing in the 24 appellant.
He can't come to court today.
All right, my lord, only my fear is that, my lord, it will be the next Friday or the next Wednesday, I will not be here.
All right. On that day, somebody can represent. We will adjourn it. See, otherwise, to take it out of the list, etc.
Can you make it not today? I will mention.
In anybody in that Casta appeals.
My lord, in item number, my lord, 20, my lord, we have served twice, my lord, but could not succeed, my lord. If your lordship kindly direct us to serve it through the department, we want to take some as a last chance, my lord, so that it can be done.
All right.
Item 21, my
Item
lord.
21, no?
21. 20, my lord, sorry. Item
20.
20.
The appellant directed to serve fresh notice on the respondent through the department.
My lord, since it has been submitted that the notice which have been served was returned back.
Since the notice which was sent has returned.
My lord, item number 18, my lord, both we are appearing, my lord. To be very candid, if your lordship, this issue has also decided by your lordship in another appeal. If your lordship kindly consider this.
For the orders of
18.
18, my lord.
18.
Commissioner versus
Hamcha. I am led by Mr. Shiv Shankar Banerjee, my lord. It's a case of, my lord, fire broke out in the premises where the factory of the respondent situated. Due to devastating fire, the entire finished, semi-finished product was destroyed. Thereafter, they filed a remission application under Rule 20 of the Central Excise Rule 21. So that was rejected. Subsequently, they preferred an appeal before the Planet Tribunal. When Tribunal had allowed against this, my lord, we have preferred this appeal, and that my learned friend George handed over that order Sorbovary impact. This is the same premises where that both the companies situated. If your lordship kindly consider this.
Yes, we remember.
Yes, my lord,
Yes, that is, this is
same premises.
Same premises.
Both matters were taken up together by the learned
That's
tribunal
right.
below.
All right.
And my lord would find that order at page 39.
39, yes. Please come, sir. This appeal has been filed by the Central Excise Department, Central Excise and Service Tax Department under section 35 capital G of the Central Excise Act 1944 within bracket the Act against the order dated 26/7/2023 passed by the Customs, Excise and Service Tax Appellate Tribunal, Calcutta within bracket Tribunal in excise appeal number 75332 of 2017. The revenue has raised the appellant has raised the following substantial questions of law.
Page 22, my lord.
Page
22 of the state petition.
questions of law for consideration. A, B, D, capital E, A, B, D. We have heard Mr. Shiv Shankar Banerjee, Senior Standing Counsel, for the assisted by Mr. Tapan Banja, Junior Standing Counsel for the appellant, and Mr. Swansu Mukherjee, a learned advocate, appearing for the respondent. The tribunal, by the impugned order, allowed dismissed 2 appeals filed by the department, namely Excise Appeal number 75332 of 2017 and Excise Appeal number 75461 of 2017. As against the order passed in Excise Appeal number 75332 of 2017, the department had filed an appeal before this court in Sexa 5 of 2024, and by judgment dated 9th July 2024, the appeal was dismissed. The operative portion of the order is as follows. Page 40 of this compilation, which has been filed by the page 40, page 2 till page 3M. Okay. The present appeal also is on identical facts and concerns the very same premises where a fire accident took place. Therefore, the above decision will squarely apply to the case on hand. Following the above decision, the appeal stands dismissed.
My lord, one indulgence, my lord, is recorded in Sexa 5 is arising out of Excise appeal number 75461. My lord, is recorded subject to correction, my lord, 75322. It should be, my lord, 75461.
75461.
61, my lord. Wait for me.
Be clear, please.
Yes. 19. No. 19, you're not.
Write down 19.
21.
My lord, in item number 90, I'm praying for not today, man.
All right.
21.
21, my lord, Mr. Uday Shankar Bhattacharya has been newly engaged, my lord, in the
No,
place
he's
of.
now there on online.
Yes.
My lord, I am on virtual mode.
21.
Not today.
Not today.
I'm not 22. Lord, 22, I am also playing not today, Mr. Day is playing.
23. 24.
24, my lord, Mr. Day is appearing. If I am appearing.
25.
My lord, I am appearing for the respondent, my lord. 25.
Who will appear for?
Mr. Day is appearing, my lord.
Not today.
26.
Not today.
27.
Well, I am praying for not today, man. 27, I am praying for not today, my lord.
28.
28 and 29.
28, 29.
All right, then proceed.
For admission, appeal number 30.
30, my lord, I am appearing for the appellant. So this was served, my lord. They have received, my lord. There was a delay, my lord. Delay was condoned on the last occasion, my lord. We have filed. May I file of service, my lord? No, this is regarding of it's a penny stock, my lord. Reopening was done. If your lordship will kindly come to page number 9, the assessment order, my lord. If your lordship will kindly see, my lord, it was subsequently it was informed that information was received that during financial year 2011-12, it sold the BSC Skips Agam Capital Limited having code number such and such, which is a penny stock. As per the report of the report furnished by, it has been seen that for the generation of bogus long-term capital loss, capital gain, the complete transaction was purchase and sale of a penny stock was managed and by the manipulated with bogus transaction of capital loss and therefore that amount should be bigger. SSC has taken the benefit of such and such. The reopening was done by the assessing officer. Before the CIT appeal, they, it's an ex parte order, they took several adjournments, it's not that, the opportunity was not given, they took several adjournments. Sometimes relevant documents were required, but no documents are produced. Therefore, CIT appeal has, if your lordship will kindly have a look at the order of the CIT appeal, he has confirmed, your lordship will kindly come to page number 18, your lordship will kindly see, during the appealing proceedings, the appellant has only submitted the submissions in the form of statement of facts. After that, neither he has replied the hearing notices nor not submitted any documentary evidences to prove the side. The sufficiency of the adequate opportunity were afforded to the appellant as indicated in the table pages number 2 of the reply whatsoever.
No, this is a case of reopening.
Yes, reopening, yes.
But then you please see the finding recorded by the
yes,
tribunal.
But tribunal says that it's all recorded in the books of account. Therefore,
Yes.
But the difficulty is CID
they have referred to this infinity in.
Yes, that I've seen, that I've seen. But the difficulty is before assessing officer, they have not said anything about CID before the CIT appeal. Also, he did not appear. He took adjournments. His observations were page 18. I understand that is there,
And you are having that decision infinity in.
Right.
Case number also you don't have. We can open it here.
Just a minute. The line looks looking at him.
All right, sir, please come. This appeal filed by the revenue under section 260 cap A of the Income Tax Act 1961. Within bracket, the act is directed against the order dated September 12, 2023, passed by the Income Tax Appellate Tribunal A Bench Calcutta within bracket tribunal in ITA number 400/KOL/2023 for the assessment year 2012-13. The revenue has raised the following substantial questions of law.
Questions about page 4, paragraph 7.
We have heard Mr. Prithvi Dorial and at senior standing counsel appearing for the appellant. The respondent has been served and affidavit of service has been filed, but none appears for the respondent. Though the department would contend that the matter relates to a penny stock, the issue which was decided by the tribunal was whether the reopening of the assessment was valid. The assessee's contention was that the reason for reopening of assessment was that the income of rupees 88,73,135 had escaped assessment, which is generated by the assessee from sale of penny stock. This reason was found to be incorrect since the assessee found to be factually incorrect since the assessee has not shown any income from long-term capital gains / short-term capital gains / business loss, and therefore the tribunal came to the conclusion that the reason to believe is bad and consequently the reopening is illegal. The learned tribunal took note of the decision of this court in CIT versus Infinity Infotech Parts Limited, IT 8060 of 2014. Thus, we find that on facts, the tribunal was convinced that the reason for reopening was bad in law. Apart from that, the tribunal noted that the alleged transaction has already been recorded in the books of accounts and has been disclosed in the income tax return filed under section 139 within bracket 1 of the Act. And therefore, the very foundation of reopening of the proceedings becomes bad in law. Reference was also made to the decision in the case of CAT versus Jet Airways India Limited 331 ITR 236 and Ranbaxy Laboratories Limited versus CIT 336 ITR 136. Thus we find there is no question of law, much less substantial question of law arising for consideration in this. Next.
Item number 31. But I'm appearing in this case. Mr. Rajushi Chatterjee is appearing on the other hand.
I'm appearing for on behalf of Mr. Rajeshri Chatterjee. I'm playing for not today on.
Not today. Next.
32.
My lord, appearing for the respondent, my lord.
Yes.
I'm appearing virtually, my lord, respondent.
Yes, sir.
My lord, in this matter, earlier assessment was reopened at the behest of the SSC. After passing of the reassessment order, the PCIT found that there was non-application of mind or non-examination by verification by the assessing officer and passed direction to pass assessment order of rate. Assessing officer passed the assessment order that was challenged, and that 263 order, my lord, that was not challenged by the SSC. The SSC went in appeal before the tribunal. Tribunal set aside the deleted the addition made by the assessing officer.
But all the subscribers have responded to the 133.6 notice.
My lord, kindly come to the 263 order first, my lord. But there was a specific direction. 263 order is at page 13, my lord.
30.
13, 13.
13.
My lord, the directions are at page 18. In view of the special facts and circumstances as well as the judicial decision relied upon, the impugn order under section 148 is therefore set aside. Directions are: examine the genuineness and source of share capital, not on a test check basis, but in respect of each and every shareholder by conducting independent inquiry, not through the SSC. The bank account for the entire period should be examined in the course of verification.
to find out the money trail of the share capital. Further, the AO should examine the directors as well as examine the circumstances and necessitate the change in directorship. If applicable, he should examine them on oath to verify their credentials as director and reach a logical conclusion regarding the controlling interest. And my lord, kindly come to page 30, my lord. What is the backdrop for giving this direction, my lord?
Before the tribunal,
My lord.
some paper book appears to have been filed. That's what the tribunal records.
My lord, the
Because
tribunals
the-
are recorded.
the
These the 133(6) notices that were issued. These were issued prior to 263 proceedings, my lord.
Have you got a copy of that paper book?
No, my lord. I do not
My lord,
have.
the paper books are with my counsel in the court, my lord. And all the notices, even after the 263 order was issued, thereafter again notices were issued and again it was complied. Kindly see, my lord.
If your counsel can,
Yes, certainly, my lord.
then you give copies to Mr. Sharma also.
Yes.
So we'll take it up next week. In the meantime, let the counsel go through these papers. The learned advocate appearing for the respondent assessee has filed a compilation containing the documents which were filed before the learned tribunal, copy of which has been handed over to the learned advocate for the appellate. Based on so and so date.
Second.
Yes, sir. Thank you. Next.
Obliged, my lord.
Item number 33, my lord, in 33,
My
I'm
lord, in
praying
this
not
matter,
today.
I'm praying for not today, my lord. I received the brief day before yesterday, my lord.
Not today.
Item number 34,
Lordship, I am for the respondent, Lordship, I am praying for not today.
All right.
35,
I appeal my other side is not here. May I please the
Respondent served.
delay was also condoned on the last occasion.
Who appeared when the delay?
Obhijit Akal Dhudewala and Kush Kanodia, my lord. Not known to us.
All right, not today.
Then both the matters, because for the two different assessment years, my 34, Naki? 35, 36.
item number 37,
37 is also my application, but I find the other side is also.
All right.
38,
Where both sides are there.
Both sides are in one matter, my lord, 45.
38,
That can-
39, not today.
Yes.
41.
39, I am appearing, my lord. In this matter, similar questions of law in another matter has been admitted.
Who will appear for the department?
I believe Mr. Om Narayan Rai is appearing.
I'm praying for not today.
Then
39 and 47 are arising from the same tribunal's judgment.
okay, both not today.
Item number 42.
Any matter where which is your matter?
Item number 45, my lord. I'm appearing for the respondent in that matter.
I am for the assessment. Your Lordship, the question. May I be permitted to file the affidavit solicited?
Yes.
Question of law at page 6, my lord. This is against the order of penalty imposed by the assessing officer, your lordship. The tribunal's order starts from page 29, my lord.
24.
24, I stand corrected, 24, my lord. And page 25, paragraph 5 is the finding of the tribunal.
Sir, my
But
humble
prior to that, my lord, if your lordship kindly takes up the CIT's order once, my lord, the CIT has confirmed the order of the assessing officer, page 23. Since the assessee did not appear, my lord, so giving ample opportunities to the assessee to appear before the CITA, but they have failed to appear, and the CIT has upheld the order of the assessing officer. Now, the assessing officer, the order of penalty is at page 19, my lord.
But merely because during the survey,
Yes,
he
my
is
lord.
supposed to have admitted.
Survey.
But penalty proceedings are separate.
271 once is not applicable, my lord.
Pardon?
271 once is not applicable. I suo moto offered my sum as for income from other sources. It is not, making an incorrect claim, my lord, is not, my lord, in furnishing inaccurate particulars, my lord. So there was no concealment, no inaccurate details furnished. And they can, as far as best make, my claim has to be incorrect. But section 271 once, my lord, cannot.
That is some that reliance judgment is there.
Yes, my lord, I have that
judgment
realized
yes.
judgment, my lord. They are relying that judgment, my lord.
That has been, my lord, this has been recorded also in the ITAT order.
Are you giving it?
Yes.
The issues before your lordship is with regard to that not disclose the particular penny stock, and also the section 10, subsection 30, the exemption claiming the extension of the capital gain, my lord. Now,
No,
if
there should be a finding of concealment for 1C to be attracted.
your lordship kindly takes up the order of the penalty, my lord, once. But prior to that, if your lordship kindly takes the order of the assessment, it starts from page 11, my lord.
Incorrect claim was made.
Yes, my
It
lord.
was not accepted by the AO, will not constitute the what is it? Will fall within the expression inaccurate particulars.
My lord.
As an assessee, he can claim even the sky. It is for the AO to accept or reject. But dubious method he has followed, inaccurate particulars, or suppressed facts, or made a wrong claim cannot attract.
Neither there was concealment nor inaccurate particulars. Well, I had suo moto offered my sum as income from
There's
other
nothing
sources.
there, madam.
It is only because of at the time of the survey operation, they have disclosed their.
All right. With that, please come, sir. This appeal by the revenue filed under section 260 capital A of the Income Tax Act 1961 within bracket the Act is directed against order dated 30/11/2023 passed by the Income Tax Appellate Tribunal A Bench Calcutta in ITA number 705/KOL/2022 for the assessment year 2015-16. The revenue has raised the following substantial questions of law for consideration. Page number 6, A and B.
May I be permitted to only intervene on the page 16, your lordship, with regard to the fraudulent transaction? This point may be taken into consideration, my lord. The why they are saying that for the initiation of the furnishing the inadequate particulars of the income because the proceeds of the fraudulent transaction. That was the only issue. The
But if it
assessing
has been
officer
offered,
at the time of the survey only, but not prior to that, my lord. Is only when the survey has taken place, then only they have offered.
the question involved in this appeal is whether the assessing officer was justified in imposing penalty under section 271 within bracket 1 within bracket C of the Act. The learned tribunal, on going through the facts, found that the assessing officer nowhere demonstrated that the claim of the assessee was either found to be false, either during the assessment proceedings or during the penalty proceedings. In this regard, the learned tribunal took note of the decision of the Honorable Supreme Court in the case of Commissioner of Income Tax, CIT versus Reliance Petro Products Private Limited, 2010 SEC 762. The decision arrived at by the tribunal is just and proper. Since the assessee has fully disclosed the particulars in the return of income and section 271 within bracket 1 within bracket C do not stand attracted. For the above reason, the appeal is dismissed and the substantial questions of law are answered against the revenue. Next.
I'm grateful, my lord.
My lord, item number 41 may not be taken today.
Item
41, my lord.
41.
My lord.
Madam, your appeal.
Yes, I'm.
What is this matter? 41.
My lord, I am contemplating to go to Vivad Se Vishwas, which is yet to be enacted, though it has been announced in the finance act.
Because
For
the settlement. Mr.
already-
Surana, you're talking about the settlement.
Yes, we will be going. That's why I am.
So the
praying
form
for
number
amendment.
5 needs to be filed before the court.
No, actually, the finance bill is yet to be passed. So once it is passed, we will do it. It has been proposed in the finance bill.
So let it be kept alive because they
We'll
need to
adjourn
file
the
the-
matter?
Yes.
All right. At the
My
request of respondent, after related come after 3 weeks.
My lord.
Then in any case, both sides are ready.
Deeply appreciate.
My lord.
Then what about this group 9 admission? We'll come back on top one. So should we'll come back, not required.
Hello. May I be permitted to mention it's a very urgent matter, my lord. It relates to my life. I am personally interested. My lord, in the year 2000, there was an attempt on my life to forcibly occupy our properties at Jalpaiguri. I was saved, luckily, as the local villagers, they informed the police about the matter which I am just saying. They were suspecting that something is going to happen, but they had no courage at that time to obstruct it. They just informed the police. And luckily at that time, relevant time, it's just village on the Holdiwari road. I don't know, my lord, whether lost yet. It's a more or less highway. It's just within 40 minutes or 30 minutes from the present circuit bench of Jalpaiguri. Just imagine, my lord, the situation. I was at that time, 2000 back, I was advocate of this honorable court. And I had my cases here. And one such client of Jalpaiguri, on whom behalf I just placed a application here for his service. And as he was a resident of Jalpaiguri, and we were also permanent resident of Jalpaiguri. So out of our profession, but some personal relation, it's normal. In small towns, it happens. And one day he came to my house in Jalpaiguri. I told him, we are in holiday mood. Let's go to the village. Just for a casual visit. I said, there is our property. And he also agreed and accompanied me there. When I got down from my bus, I heard that some betel nuts is value what? Maybe 100 rupees or 2,200 rupees. Is the matter of searching? It was right in the garden. Somebody told me, yes, Omidda, we used to call in village, not son, no, yeah. Brothers, kaka, this and that, we used to call. Omidda, you have come, we are happy. Can you just give me some money to celebrate? Oh, no matter, no problem. After a long time we are meeting. It's out of any interest. It's normal, as if we were very close, we are like brothers or uncle or this and that. I told yes, no matter. I asked somebody in the village to go and climb the tree and get down with some petal nut and sell it and give them some money. It was not at all a serious matter. The person went there to pluck. They were registered. They were registered by some person of the village. Why you are climbing? They told, Omidda has told me to bring down that year. And I will be taking this and I will pay for it. No, you can't do it. They came immediately to the place where I was standing. It was a place just adjacent to the village, it is known as Mode Crossing, and it is a small market. Small market. Every time there is bus, auto, taxi, tea shops, and all such things. It's not a solitary place. All the time, till night, there remains people for many reasons. Small marketplace in the village. It has got importance. They came to me, two brothers, challenged me, why you have asked them to bring down the here? I told, this is our property. That property belongs to me and my elder brother. I've got right. Yes, I am showing you, you're right. Two brothers caught hold of my two hands. They dragged me from there through the village road. That's not solitary. There are houses by the village. It's a teeny village, might be, but there are houses.
But what do you want from us?
My lord, kindly give me, my lord. They dragged me and pulled me there on the spot. And there, they beat up in the road mercilessly, and ultimately they pushed me in a room, and two others also entered in the room, and they were telling, yes, we'll just show you your right. This property is ours, not yours. Forget about it. And we'll take such steps so that there will be nobody to claim it any further. But in the meantime, my lord, it's grace of God that police was informed. And luckily, a patrolling van was just passing by. They got the message and they came down. And I was scared. But thereafter, my lord, actually, I am the witness, I am the complainant, and I am the person, victim. The properties are remaining till date 24 hours. It's a matter of 24 hours. Yes. This period, my lord, the property is under siege of them, and the culprits who ventured to take such a risk. Because normally, my lord, in a small town or village, advocates are known. They have got some respect. How they could dare to pull me through village at about 11 a.m. in the morning. We were so many people, and there was nobody to object it. Till 24 years, nobody came out to tell anything. Normally, the matter came before the trial court, and there was no witness. It was decided 258. It was discharged. Then I came down to Calcutta High Court, filing revisional application, and it was admitted. And lastly, my lord, in the year 2023, Honorable Justice Siddhartha Roy Chaudhary was pleased to pass an order that the order of the lower court be set aside. And also, because Lordship knew, Lordship came to know through my application that I am a patient of heart, cancer, and kidney. My lord, this is my health condition today. 24 years back, it was not that. This is my condition, my lord. And considering this aspect also, and because of the time factor, Lordship Raichaudhary, my lord, gave order to the lower court. You should not waste time. I am giving you time that you should dispose of this matter within 6 months. Lower court didn't obey. I filed a contempt petition in High Court, and Justice Raichaudhary inquired in Jalpaiguri Court. First, above, the judges of Jalpaiguri Court told him, don't worry, that we will obey your order, and already we have sent a message to the criminals and also to Amit Moitra, petitioner. The case will start. No problem. Then, my lord, I got no sum. I become suspicious. That there might be something, because behind those accused persons or culprits, in every case, my lord, in everywhere, especially in West Bengal, there must be some big hands, big head, who doesn't appear in front, but they support them by their influence, by their money, by their anything. And they have a vested interest behind any such move. Even today, just the Arjigar matter, it's like police did not give any such complaint, and no action was taken. They were not arrested. Nothing.
Now, what do you want for?
I want, my lord.
What is that?
This is the case. And this matter was also referred to you by Honorable Justice because there had been some kindly. Ajay Gupta, my lordship, by Ajay Gupta. It was assigned to Ajay Gupta for taking necessary decisions. And ultimately, that matter, on the basis of the order of this court, Honorable Court, Ajay Gupta, I filed a petition, my lord, here in this Honorable Court, CRR 278. It's challenging the very order of Jalpaiguri Court, that the new case also, in that new case, which was ordered by Honorable Justice Raichaudhary, they did not, this time also they didn't comply to. They just started this case without informing, without giving any.
Now, CRR 278 is pending.
Yes, it is pending.
Now, what do you want from us?
I
sir?
want, my lord, this case this time.
Huh?
This case, CRR 278. It is in the list, and Honorable Justice Subra Ghosh heard this matter and passed also, and my lord, just a minute, and heard also this matter and passed her order. It is also.
Yes, we saw that.
Problem is, I don't know why. This matter has been listed in Jalpaiguri jurisdiction, circuit bench, because the persons in the court, they thought it is Jalpaiguri matter. They listed it in Jalpaiguri. And I think it is the fit case, not for Jalpaiguri, but it should be in High Court. It is for my health I need. It is not possible for me to go down to Jalpaiguri often. It's not possible. I do not have any control over me. I do not know. But in Calcutta, I am under medical surveillance. I've got to attend dialysis, my lord, twice a week. And so many other hazards, lordship can quite understand with the health. In this way, I have served already to all the respondents as per order of Honorable Justice Subra. Just day before yesterday, I want to serve the copy to learned PP. They refused to accept it because they told, it's not a matter. Why got no locus standi to receive it? It's a matter of circuit bench. My problem is first to deliver. Next problem is if it is under jurisdiction of Jalpaiguri, then sometimes it may happen. I'll be perplexed. It may happen. It's not unlikely that I may have to be asked to appear before. As in the last order of Jalpaiguri Court, they asked me to attend must on 5/11/2024. It is the order of the JM Second Court at Jalpaiguri on the basis of the order of Honorable Raichur.
No, this matter.
I want, my lord, this matter should be in High Courts, regular bench. Just it is in Honorable Justice Subra Court.
No, on the administrative side, I cannot do it.
Yes, my lord.
Because the matter was filed in Jalpaiguri Circuit Bench. CRR
Actually, my lord, I didn't file. I filed here, having a faith that it will be in the High Court list. But unfortunately, my lord, that's why on the date when the matter came up, I was perplexed. I didn't know.
No, you filed it in the principal seat. How did the papers go there?
I just filed it in this filing section. But I didn't mention anything like Jalpaiguri or Calcutta because.
Then who sent the papers to Jalpaiguri? Who sent the papers to Jalpaiguri?
I did not do anything. I did not do anything.
All right, we'll verify. We'll verify from the circuit bench how the papers went there.
Secondly, my lord, it's a matter of life and death for me. As an advocate, it's a very inglorious, and also because of my disease, I don't know what is tomorrow. In this position, my lord, I don't want to miss the date which Lordship Justice Ghosh has given, 30th August. The date fixed.
On that day,
I must be present.
No, you can appear virtually.
My lord, there are so many problems. My lord, I have told, my lord, already submitted, my lord.
All right, you do one thing.
For any crime, say for instance of this Arjikor affair, Any
You do one
matter,
thing.
there are people.
No, you can do one thing.
Big
You,
hands.
you appear on 30th August in the circuit bench and request.
I won't go.
You won't go.
No. The date which is fixed by Honorable Justice may be under circuit bench. If the circuit bench is not in operation on that date, might be. I will abide by the order of Honorable Justice Subramanian. In the meantime, my lord, I want, let Lordship verify anything from any quarter.
No, unless you move an application for transfer, it
Yes,
cannot be.
in that application for transfer,
No,
I have already submitted, my lord, with the CRR 278.
CRR 278 is in the circuit bench. If that CRR has to come to the principal bench, you have to move an application. You, in that matter, you want a transfer from Judicial Magistrate Second Court Jalpaiguri to any other court in Kolkata. That is the application file. But that CRR 278 is before the Jalpaiguri bench. I
Yes,
cannot
sir,
drag
my
it
lord.
on the administrative side. No.
My lord, kindly, I refer here, my lord, and the order. My lord has got power under the order of Honorable President regarding the establishment. And my lord has power to take any decision.
Maybe.
To take any decision.
All right. In
Yeah.
this matter, have you served notice on the respondent?
Yes, my lord, accepting PP. PP here, I want
He
to.
here will not accept unless the paper comes here.
And in my letters also.
All right. What you do is you express a grievance by way of a letter and hand it over to the court officer. I will see what I can do on the administrative side. You give it now.
My lord, kindly one thing, my lord, before I leave. To me, every day is important.
Yes.
You can quite understand what I mean.
You give it now. You please write down and give it along with this order. I will do something. I will verify what can be done. Okay. Take it.
Sir, I want your lordship leave to mention
Grateful, my lord.
one lead application, your lordships are read petition number 28142 of 2013 was filed, and another read petition WPA 89 of 2023 was filed at different in nature, but due to misunderstanding of language, both disposed of with similar order, but these two matters are different in nature and similar orders will prejudice. I pray before your lordship that I have written my query in this paper, which I am submitting now, and pray before you to my read petition WPA 28142 of 2013. सर उन्होंने आपने मेरा गलती से
It has been disposed of. Which bench we have?
এক ছিল, দুটোই ছিল, একটা ডিসপোজ ঠিক আছে, আর একটা আমার ভুলেতেই আমি ভাষা বুঝতে পারিনি, হিন্দিতে বলেছিলাম, আর উনি ইংলিশে যখন বলেছিলেন তখন আমাকে পাশ থেকে একজন বলেছিলেন, আমি হ্যাঁ বলে দিয়েছি। সমস্যা এখানে।
Was also. Then he let him file an application. Some application will file. That leave granted. You file an application.
Sir, thank you, sir.
একটা অ্যাপ্লিকেশন ফাইল